Welcome, everyone. I'm pleased that you are able to join us today. Before we get started with our program, I'd like to go over some housekeeping matters. First of all, if for some reason you bounce off of the webinar and sign in using a different ID, please email me at lori.nelson@law.utah.edu so I can make sure you get credit for the full hour. Pursuant to Utah Supreme Court rules, you have to stay on for the entire hour to get credit. So I want to make sure everyone that stays on for the amount of time gets credit. The second thing, there will be time for questions at the end. Please use the Q&A feature, not the chat feature, so we can make sure that we get your question answered. If you see a question that is similar to one you were thinking of asking, you can click a like button and that will raise the question up in the queue. Now, it is my privilege to introduce to you two speakers, Rick Canute, who is the special master, right, Rick, for water law cases, and Michael Drake, who is the assistant state engineer over water adjudications. Before you guys begin your formal program, will you sort of tell me how it is you came to these positions and what it is briefly that you do?
Go ahead, Mike.
Yeah, so Michael Drake, I'm an engineer, I'm not an attorney. I just play one in water rights. I've been with the Division of Water Rights for the last 10 years or so, and prior to that, I was a consultant, worked for a private consultant in Salt Lake. And so, you know, I kind of just stumbled into water rights by accident, really enjoy it. And I've been in this current position, the assistant state engineer over adjudication, for the last, well, let's see, I guess it's about 3 years now. And seen a lot of growth and speeding up of the adjudication process in my time.
And I'm Rick Canute. I'm a proud 1980 graduate of the University Law School. I am in my 43rd year of practicing law. Hard to believe. I was appointed as special master in the Utah Lake and Jordan River general adjudication in 2016, and in the Virgin River general adjudication, I believe, in 2019. And I'll be getting more into what it is I do later on in the program. But we're going to start off with Mike, who will lead.
You guys take it away.
So I'm going to lead off here and talk a little bit about the general adjudication, and then Rick will chime in on the work of the special master. So let's dive into it. So what is general adjudication? The general stream, or the general adjudication, joins and binds all water users and the state engineer as parties to litigation to basically to settle the water rights in a certain area. It is you know, these adjudications are long-standing things. We've been doing this since the earliest days of statehood. The early areas that we adjudicated were the Weber River and the Sevier River. And so these are kind of built into Utah water law, and it's how we quantify water rights in the state of Utah. They need to be adjudicated. And I'll dive into a little bit more in some greater detail here shortly, but as we move through areas, it's really important to participate. Failure to file a claim in the water in a general adjudication can result in the loss of one's water right. So it's really important. I guess the underlying principle, if we're talking about what is general adjudication from the outset, is we bring all the potential water users into one single court case, and we attempt to settle those water rights, to quantify them, to define what their uses are. And by all water users, that also includes the federal government. And so through the McCarran Amendment, the federal government waives sovereign immunity to participate in these state-based adjudications. Okay, so we'll dive in a little bit more detail here, but let's bump to the next slide, and I'll kind of address some of the questions of why we conduct general adjudications. All right, so prior slides, my predecessors have gone through a lot of history that lays the case for it. I think it's pretty easy to understand why we need to adjudicate. Anyone familiar with the history of the state of Utah knows that the Mormon pioneers came into the valley in 1847. It wasn't until 1896 that statehood came to the state of Utah. That was almost 50 years of development, water development that occurred in this time. One of the articles of the Constitution defined, and I have it quoted here on the slide, that all existing rights to the use of any waters in this state for any useful or beneficial purpose are hereby recognized and confirmed. Okay, so there was a recognition that all of those rights were valid. They were established according to whatever territorial rules or laws were in place at the time, and they were recognized. However, they were not quantified at that time, and so very early on, an adjudication statute was brought into Utah water law, with the idea being that the judiciary would have the authority to define these water rights. Now, digging more into this story, the very first Utah water laws didn't come on to the books until 1903 for surface water rights. And this is what we would call a pre-statutory water right. These rights that existed prior to the statutes requiring that people make application to the state engineer's office. After 1903, if you wanted a water right, you had to apply to the state engineer. Now that applied initially only to surface water rights. In 1935, this was extended to underground water. Underground water was initially thought to be percolating waters that were, more or less associated with the property. But in 1935, the authority of the state engineer was extended to underground water, and rights established prior to that date are also defined as pre-statutory water rights. Okay, so I hope you can start to see this picture of a lot of these pre-statutory rights that have varying degrees of quantification. And if we are looking to have the ability to manage the waters of the state of Utah in the way that it needs to, then we need to know what those water rights are. And the adjudication is the way that we bring those water rights into the overall water right picture. Also part, and this is an important facet in different areas, some areas more, some areas less, but we have this concept of federal reserve rights. When the federal government reserves water from the public domain, they also when they reserve land from the public domain, they also reserve sufficient water for those purposes. And that was established in the Winters Doctrine, 1908. This applies to all sorts of different reservations. The ones you would most commonly think of are American Indian reservations, but it also applies to national parks and national forests and many others. And so by enacting the McCarran Amendment and bringing the federal government into the state-based water right adjudications, we are able to quantify those rights, bring them onto the records, and better manage our water resources. There are other benefits to adjudications. Many of these areas that we adjudicate are very, very complicated. Some have had prior limited decrees that have attempted to resolve the water rights. Some have remained in a complicated fashion since the outset. And so what we're able to do through these adjudications is formally and finally organize these water rights so that everyone understands what they are, what they're used for, how much water do they need, who owns it. So those are all things. So we tend to condense a lot of these legal type actions into a single lawsuit where everyone is involved. Another aspect, and this is sometimes scary, but we do look at water right use, and if water rights are not in use, then we may recommend water rights to be forfeited partially or wholly through the adjudication. And then finally, the end game here is to get a final comprehensive decree on all water rights within the respective drainage, and this is kind of the frosting on top, that we finally get decreed water rights for all of these different claims. So moving along here, I put this slide in here just to convey the extent of the various adjudications in the state of Utah. You can see, the Bear River, the Utah Lake Jordan River, which is where we're most actively working now. But these are generally conforming to hydrologic boundaries throughout the state. The very earliest ones, the Weaver River and the Sevier River, have been decreed, at least as far as surface rights are concerned. And we're working hard on the other areas in the state. I've also included a little snippet. I want to drive home the idea that we adjudicate geographically. So we'll take these big overall general adjudication boundaries, and we will break them into small bite-sized pieces that we can adjudicate. You see here the Upper Provo River subdivision, which we just recently commenced, and this week sent out the notice to file claims. And so the water users in this area are right now preparing their water user claims for submittal to us and ultimately to the district court. So I'll go into the process more here, but let's dive into it so that you can start to understand some of the terms that I've been throwing around here. All right, so this is the adjudication process, and I know it's very, at least from the outset, looks very complex. It's easy to think of this in 3 phases effectively. And the first phase starts with the petition, and then it moves through to an initial public meeting, and it ends in a notice to file claims. Okay, so this notice to file claims is when we send out the notice, we send out a summons, and all of the water users in an area are required to submit a water user claim within 90 days following that notice to file claims. Now, I'll dive into a little bit more what that means in the next few slides, but that's the first phase. The second phase is the list of unclaimed rights phase. In this phase, we look at our records and we compare that to the claims that we've received. And if there's a right that has gone unclaimed, it gets put onto a list. And we file that with the district court with the intention ultimately of having those rights abandoned. The third phase is the claim evaluation and proposed determination phase. And so this is where we do most of our work. I have a whole bunch of staff members who their job is to go out into the field and evaluate all of these claims in detail and figure out what are they good for, what are they used for, how much water is it, where is it used for. We put all of that information into a proposed determination, which is filed with the court, and then there's this opportunity to object. Again, I'll get into more detail in the following slides, but I want you to understand here that the adjudication process, while seemingly complex, is really broken down into those 3 phases. So phase 1, a little bit more detail here. All right, so the petition is typically not relevant today. These, if you remember a couple slides back, the statewide map that I had, all of those adjudications, all of the state of Utah is currently under a general adjudication order, and so the petition has already occurred. So normally, the way an adjudication commences is we will start with a notice of commencement that is published in a local paper, and then also we send out a summons. Now, this is probably if you've ever been involved in it, this is probably where you first get your exposure, because we send this summons to all known water right owners of record and to all property owners of record. And this is to make sure that we give the opportunity to as many people as possible to enter into the adjudication and file a water user claim. We also hold a public meeting at this point. A few weeks ago, we held one up in Francis. It was extremely well attended, and so we do that, and then typically a couple weeks after that, we send the notice to file claims. This is a notice that's also put in the newspaper, but we mail the notice to all of that same group that we sent the summons to, all known water right holders and all property owners. And they're given then 90 days to file a water user claim. And it's important that if a claimant does not participate, they may be prevented in the future from asserting a claim. And so it's really important to participate, and it has very lasting effects if you don't participate in the adjudication. Real quickly here, this is what a water user claim looks like. When we send out the notice to file claims, we will, if you're a water right owner of record, you'll get a partially completed water user claim in the mail. If you receive the notice to file claims as a property owner, you'll receive a blank water user claim. And these forms look like a lot of the other forms that we have at the Division of Water Rights. That form, the water user claim, needs to be filed either with the district court or with the state engineer. Any claims that are filed with the state engineer are ultimately filed with the district court. Claims are only required on perfected water rights. And so this means certificated water rights, decreed water rights, and diligence claims. Applications to appropriate are not adjudicated in the adjudication. And it's important that all entities understand that they must participate in the adjudication, and this includes the federal government. They are also required under the McCarran Amendment to participate in the adjudication. An important little detail here is irrigation company shareholders are typically not required to submit a claim. The irrigation company rather submits a water user claim on behalf of the shareholder. And then one of the most common issues we have, and I want to get this out to as many people as we can, is a water user's claim does not update ownership with the division. That still has to be done separately through a report of conveyance or some other updating document. So let's move along here to phase 2. This follows the notice to file claims. Again, I think I described it briefly, where we'll compare the claims with the known water right owners, the water right numbers. And if we find a water right that has not been claimed, we put it on the list of unclaimed rights, and we file that with the district court. There's 90 days to object if your water right ends up on that. We hold a public meeting to talk about this, and then once we send out a final summons. This is the summons that is kind of along the lines of, now's the time. If you haven't yet participated, you really need to get your water user claim in. We'll look at the various objections to the list of unclaimed rights, resolve them, and then petition the court to abandon those rights and close the area to subsequent claims. So this is really the point where if you haven't participated yet, you are forever now barred from participating in the future. Moving on to the third, this is where we do the most work. Claim investigation usually takes several years in most areas. If you remember back to that little map of the upper Provo, all of those little dots that I showed there were all water rights, and so we need to evaluate each and every one of those. Once we've reached the end, well, as we move through this claim investigation, we prepare what's called a state engineer's recommendation. And this is an initial take as to what the state engineer is going to recommend in the proposed determination. Once we've prepared an SER for every single water right, we compile that into what's called the proposed determination and file that with the court. And just like with the list of unclaimed rights, there's a 90-day period to object. And we hold another public meeting. And then we enter in the phase that Rick is most involved in, and that's the objection resolution phase. And and he'll dive into this in greater detail. Now, real quickly here, I'm going to show you real quickly what a proposed determination looks like. I know we have a question. I'll talk real quickly about this, about the proposed determination, and then we'll stop a minute, I guess, to take a question here. So this is an example of a proposed determination page. You can see, if you're at all familiar with the work of the Division of Water Rights, this looks like a lot of the other forms we have. It talks about the owner of record, what type of right it is. It gives a quantity of water. This is typically in acre feet, which is a volumetric measure, or CFS, cubic feet per second, which is a flow rate. It gives a point of diversion. It gives the beneficial uses. In this case, this water right is owned by the Department of Transportation, and it's a right to irrigate 0.33 acres, and there's 11 domestic units attached to this. And then finally, the place of use is shown. So this is pretty common for proposed determinations on most rights. All right, so I will take a quick break here. We'll just look at the Q&A. Okay,
I think this question everyone has. Do individual homeowners have water rights? Or are they automatic, or what do you have to do?
Yeah, so that's a great question. That depends on the situation and how you receive water to your house. For example, I live in Sandy, and I receive water from Sandy City. When we adjudicated the Sandy area, and that was broken into several different subdivisions, Sandy City filed water user claims effectively on my behalf. However, if I own a house up in Francis or Woodland, like these areas that we just recently commenced, I may have a well that provides water to my property. In that case, I probably do need to file a water user claim and participate in the adjudication. So I hope that it entirely depends on how you get your water as to whether you need to submit a water user claim. If there is a layer of a water company or an irrigation company or a city that's between you and where the water comes out of the ground or gets diverted from the creek, then you probably don't need to file a water user claim. Most people that have water rights know they have a water right.
What about capturing rainwater?
Yeah, that's a great question. That's a different, in the state of Utah up until I think it was around 2011, or maybe it was a little bit before it. The answer to that question would have been yes, to capture rainwater, you need to have a water right. That was changed back in that time, and I can look that up while Rick's talking. And so for smaller amounts, and it's defined in statute, for smaller amounts of rainwater harvesting, you do not need to have a water right, and thus you don't need to participate in the adjudication.
And here's a question probably for both of you. What has been the quickest adjudication, and what has been the longest adjudication?
Well, they're all long, right, Rick? They all take multiple years. Historically, these adjudications took a very, very long time. If you were to look at the petition date for most of these adjudications, they're several decades in the past. And the state engineer's office has worked on them to varying degrees depending on funding. It's largely been dependent on funding in the past. And in the last few years, the legislature has appropriated additional money to the Division of Water Rights to speed up the adjudication, most specific, focused on the Utah Lake Jordan River, which includes Salt Lake County, Utah County, Wasatch County, parts of Summit County, basically following the Provo River drainage all the way up. And so that's the area that we're most heavily focused on, that our resources are most heavily dedicated towards. But even at that, it's been running for many, many years. And the west side of Salt Lake Valley, for example, was adjudicated back in the 80s and the 90s. And we hope to, with this staffing and funding, to make it come quicker. But think on the terms of decades, as long as these adjudications have been running.
Okay, Rick, want to take it away?
I will. Could I have my first
Yeah.
slide, Mike?
There we go.
Mike has a lot of practice in doing this, as you could see from that adjudication process slide that he showed you with all of the little squares in it. The state engineer has to do 3 public meetings in every subdivision, and Mr. Drake does all of those for her. So he gets to do this roadshow a lot. The process, the general adjudication process, the original statute was what I call a dip, pen, and ledger process. It was totally incapable of handling the number of water rights in a general adjudication of even modest size today. They didn't have these things called computers and word processors, and it was a very antiquated statute. In the Utah Lake and Jordan River general adjudication, in which I serve, one of the 2 I serve in, that case was filed in 1936 as a private water dispute. I believe it was converted to a general adjudication in 1947, and its area was expanded again in the early 70s, and it is the longest continuously pending piece of litigation in Utah judicial history. In 2016, pardon me, the legislature apparently detected a certain lack of progress. And so they undertook some statutory amendments to enliven the process, so to speak. There was a real bottleneck at the time, and they cleared away a lot of the legislative impediments to getting these cases up and moving, and provided a lot of additional funding. The statutory change that affects me most directly is that the statute was amended to allow for the appointment of a master in general adjudications, provided the funding exists, and they made sure that the funding existed. And in the general Rule 53, which covers masters under the rules of civil procedure, the parties must consent. That was eliminated from the general adjudication portion of the water code. And they did some other tweaking which streamlined the process. It placed more burden on the water right owner and less on the division to prosecute the claims and making sure that people are involved in the process. It was an experiment that was patterned after what several other states are doing, such as Idaho and Arizona. And with all modesty, I think it's succeeded beyond anyone's expectations. Let's get to the next screen, please, Mike. I was appointed in the Utah Lake and Jordan River case in 2016. I worked for Judge Laura Scott in that case, and then in the Virgin River case, which is pending in St. George 5th District Court in 2019, and I work under Judge Michael Westfall. Here's my contact information and that of my lawyer, John Robinson Jr., who practices in Salt Lake with Dice Law. Next slide, please. Okay, there's a lot of good information that has been posted on the district court site and on the Division of Water Rights sites. I've included those here. Unfortunately, the district court URL you see there is a legacy. We haven't had a chance to incorporate that into their shiny new website, but that will be pending. but there's tons of information available to you on both of those. The one on the district court case or website, of course, focuses on my the stuff that I do, the objection process, but the Division of Water Rights adjudication page is chock-a-block with information that will be useful to you. Next slide, please, Mike. All right, this covers my authority. My authority comes from Rule 53 of the Civil Procedures rules, and the scope of the mandate is pretty broad under things which are within my remit. But in short, anything having to do with an objection, either an objection to the list of unclaimed rights of record or an objection to the proposed determination itself, is within my authority. The judges typically will not touch it until they get from me a report and recommendation. I supervise discovery, I do case management, I deal with motions, I issue case management orders, I do trials, all leading up to a final written report and recommendation to the judge. The judge makes the final decision based on my report and recommendation. Once that is issued, the parties have 30 days to object to the judge, to my R&R, as we're calling them. And if no one objects, the judge simply adopts the recommendation. And a clearly erroneous standard applies. My factual findings are entitled to a clearly erroneous standard of review. My legal conclusions get no deference whatsoever. Next slide, please. Things that are not within my remit. As I said before, I don't do final orders on objections. I only make a report and recommendation, but I do everything up to that point. There are a few things the judges need to do, one of which is orders for the amendment of the proposed determination or interlocutory orders, requests for extension to file a statement of claim. That makes sense because until there's a statement of claim, there's not really an objection. The judges also approve the form of divisions and subdivisions within the general adjudication. And the judges also approve the service of the commencement notices and authorize the service of notices to file claims. Next slide, please, Mike. The people who drafted the rules of civil procedure made no accommodation whatsoever for general adjudications. They just don't fit. There's no complaint. There's no answer. It is an animal separate to itself. So the first thing I did when I was appointed in the Utah Lake and Jordan River case was to issue a set of standing orders. The standing orders you will find posted on the Utah Court's website. That's the URL I gave you earlier. They are there, but it's sort of secret knowledge. You have to know they're there in order to look at them. I try to remind people as much as I can that these things exist and they need to litigate accordingly. But it's I never give up hope that they'll get the message. The standing orders will apply. There's one standing order at least for every kind of objection proceeding. There are 4 of them in the Utah Lake and Jordan River case. Those two, the substance of those 2 are combined into 2 orders in the Virgin River case, but again, they're all posted on the state court system website. Next slide, please. And here they are. These are the URLs. Next slide, Mike. All right, I'm going to use the Utah Lake and Jordan River case as my exemplar for further discussion on these standing orders. But the same rules apply in the Virgin River case. When I was appointed in June of 2016, there were about 160 pending objections in this case, mostly on the west side of the valley, that had been pending since the late 70s and early 80s and had never been resolved. I've whittled those down to about 10 now, but so relatively few objections will be still subject to standing order number 1. But because of the length of time that had passed, I felt it was necessary to have more notice given to those objectors. Standing order number 3 applies to objections that were filed after my appointment, and we don't need to observe quite the same level of due process care as for the standing order number 1. Next slide. Standing order number 4, or 2 rather, pardon me, deals with just the special case of the lists of unclaimed rights. This is a very streamlined process because there's only one party really who has standing to object to kicking a water right off of the list of unclaimed rights, and that's the state engineer. And they have yet to object to any objection to someone's water right being on that list. They're trying to be obviously as inclusive as possible in the process, and they don't want anyone to feel like they've been shortchanged. Next one, please, Mike. And finally, standing order number 4. This applies only to the objection to a proposed determination and not objection to lists of unclaimed rights. There was some difficulty early on, some ambiguity and uncertainty as to what constituted an objection within the definition of Rule 8 of the Civil Procedure Rules and how that interfaced with a general adjudication. So this standing order covers that, and it provides a form that if you use, it'll be deemed that your objection is in proper form. And for purposes of litigation, I consider that the objection is tantamount to a complaint, and that's how we've proceeded. The rules, the statute don't say that, but it makes sense. And since there's no law contradicting me, that's what I've decided to do. So your objection is tantamount to a complaint, and then the state engineer answers that complaint, and third parties, affected parties who want to join in are in effect filing third-party complaints. Next slide, please, Mike. The best way to think about a general adjudication is as a giant quiet title action. And the jurisdictional basis is quasi in rem. If you'll remember that from your first year property class or civil procedure class, the personal jurisdiction of the court extends as a result of the defendant's ownership of property within the court's jurisdictional boundaries. Because you own a water right within the territorial limit of the general adjudication, the court has jurisdiction over you. Once you dispose of that property, that jurisdiction transfers to the new owner. Now, in Utah, title to water rights is adjudicated in the same way as title to real estate. And an important principle to remember is that you must stand on the legitimacy of your own water right. You get no credit simply disparaging your neighbor's water right. You have to show the strength of your own. Next slide, please. The burden of coming forward and burden of proof. The proposed determination is prima facie evidence of what it asserts. The burden then shifts to the objector, and the objector has the burden of proving the claim by clear and convincing evidence. Although it's not nailed down really tight, I think the case law in Utah supports that, and that's the standard that I have been applying. Next slide, please. Communication with me. Same rules apply as if I were a judge. No ex parte communications. There's some special rules that are laid out in the standing orders, but the one thing you must remember is I'm not inside the court system. I see the green filing system in the same way that you do. So you need to be mindful if you're sending something for the court to sign, for the judge to sign, you send an RTF through the green filing system. Proposed orders addressed to me, you email them to me with a copy to all of the counsel that appeared in the objection proceeding and my lawyer. And I can spend a lot of time explaining why we do this, but just suffice to say, it's really important in all of your pleading titles and in correspondence with me and other parties, you must include the 3-digit number set, because the green filing system will not accommodate the subdivision system that we use in general adjudications. Each individual objection has a unique numerical designator of 3-digit sets. The first one is the division, the second one is the subdivision, and the third one is the objection number within that subdivision. And if you post documents to green filing without that, it's not searchable and we'll never find your pleading. So make sure that the title, as you index it in green filing, has that 3-digit set. Next slide, please. And this is where I pass it back to Mr. Drake.
Okay. I think I'll take a real quick minute here to answer one question that's been posed. If the Virgin River flow is reduced to the point where the city of St. George cannot supply all homes with water, how is it determined who gets water and who doesn't? The answer to this question isn't unique to St. George. This is a statewide answer, and the priority date of the various water rights come into play. In the state of Utah, our water law is based on the doctrine of prior appropriation. And so each water right has a priority date which conforms with the date that water was first diverted from its natural source and used by the original appropriator. Now, the precise answer to your question is extremely complex. In the St. George area specifically, there's several entities involved. There's St. George, of course, and then there's Washington County Water Conservancy District, who also owns multiple water rights with all sorts of different priority dates. So there's a lot of different sources to come into play, a lot of infrastructure that has been constructed to make sure that there is water for the people of, I mean, and again, this is not unique to St. George. This same exercise is done through the various levels of water administration throughout the entire state. Interestingly, there is one bill that is in the legislature this year. I think it's House Bill 150, which addresses emergency water shortages. However, I understand, at least as it's currently being recommended or discussed, the various emergencies does not include drought, and it's intended to be a short-term response to, what do we do in the case of a dam failure, or I don't know, some other sort of emergency that might require the state to take action and designate certain uses, for example, keeping people alive as the preeminent use of water in those times. But again, that would not be used for drought functions. Okay, so real quickly here, and then we're kind of running up on time here. We want to leave a little bit more time for Q&A, but I want to run you through just current status. Oh, let me see here. Oh, there we go. Current status. So this, you see a statewide map. The blue areas are areas that have interlocutory decrees on them. So you can see those aforementioned Weaver River and Sevier River. You can see that there's a lot of white on this map, so there's still a lot of work to do. We're fortunate to be in a time where adjudication is funded well, where it's recognized that this is an important piece of understanding our water picture. But it hasn't always been that way in the past, and so there is still a lot of work to do, particularly in the most heavily populated areas. All right, so I'll keep moving along here. This is the current status in Salt Lake County. We had a big year last year. We published 7 proposed determinations, which is, well, at 8 total. There's one in the southeastern Colorado River adjudication. So 8 total, which is the most that anyone's ever published. And so, that just speaks to the speed that we're achieving now with this increased funding and the resources we have. So proposed determinations were published last year. We plan an additional 3 in the Salt Lake County area, which will complete the Salt Lake County area. So the last 3 remaining are all associated with the 2 Big and Little Cottonwood Canyons. And
Mike, may I ask a question?
Yeah.
How many people do you actually have in the Division of Water Rights that are working on adjudications at this point?
That's a great question. We currently have, let's see, we're around 30, but I am in the process of hiring another 6 people. And so we are pretty dramatically expanding even now to try and meet the pace that we need to do this at.
Well, the division did 7 subdivisions last year. Before the statute was amended in 2016, I think the division was doing about 1 a decade. Yeah,
it was extremely slow. And that is notable. We haven't really gone into the difference between the statute as it was before and after, but the statutory changes that were made at that time are significant, and they lead to a dramatic acceleration of adjudication work. Certainly, and absolutely. All right, so moving on here, click the right button. Okay, Provo Division. So this is the area that's been more recently commenced. We have lists of unclaimed rights decreed in several of these areas. In fact, I just realized this is how fast we move. The Daniels Creek was recently, the list of unclaimed rights was decreed, and I did not catch that in my slides. And we have commenced everything in this division, and so we'll be looking to the next areas to continue adjudicating. Francis Woodland and Upper Provo are the 2 that we sent out our initial notices in just before Christmas. It was a nice little Christmas present for people. They don't enjoy that Christmas present, just so you know.
So for both of you, who are the people that are most likely to object and file objections? Is it individual homeowners? Is it water companies?
We get a mix of both. Most usually it's the big water users, at least what we've seen so far in Salt Lake County. But that also might be because Salt Lake County is pretty dominated by the big water users. Very few of us have wells anymore. Salt Lake County used to be covered in wells, but a lot of those have been abandoned and people have moved over to these municipal systems. And so I think that will change in the future as we move up into Heber Valley and up into the Francis Woodland areas. We're bound to get more objections from individual water right holders.
Down in the valley, Salt Lake City Corporation objects a lot, but most of their objections are technical in nature. They have a bone to pick with the state engineer on how she has described the various attributes of their water rights in the proposed determination, and those are worked out fairly regularly with the state engineer's office.
Yeah. This is the Virgin River adjudication that we are actively working in this. This is not an area of extreme focus, but the region office down in Cedar City is working on it and it is getting close. There is a chance we could publish the Ash Creek proposed determination this year. We'll just have to track things and see. But we have work still to do down in the St. George Virgin River adjudication.
And you'll note that, pardon me.
Go ahead.
You'll note that the Shivwitz Band and the Nazian National Park have a decreed determinations there. That is a result of settlements between the state and the federal government, pardon me, under the McCarran Amendment.
Yeah, thank you. And speaking of the McCarran Amendment, we're currently in the midst of adjudicating a very, very large, one of the largest reserved rights in the state of Utah for the Navajo Nation. You may have caught the news stories. The agreement was signed last May with Secretary Holland and the Governor Cox and President Nez at the time down in Monument Valley signed that agreement. And to implement that agreement, that agreement into state water law, it has to be adjudicated. And so we commenced that adjudication last year, and we're in the midst of that adjudication process as we speak. We've also done work in Moab, as you can see, and that was one of our other proposed determinations that we published last year. All right, let's see. I'll look at this question real quick. I'll hold that till the end here. Where are we going next? So we're going to continue in the Utah Lake Jordan River. That is where our funding is intended to be used at the majority. And so we're going to continue down into southern Utah County, which is as yet unadjudicated, and then into the Mona Nephi area. And then there are addenda that need to be done on all of those really old proposed determinations that were filed back in the 70s, the 80s, and the 90s in the Utah Lake Jordan River adjudication, with the goal ultimately being to complete the Utah Lake Jordan River adjudication so that it's complete, it's done. There will be no, the adjudication is completely over. We'll also continue in the Virgin River, the Ash Creek division, and then the subsequent other two areas that you saw down there. We also are working in the southeastern Colorado River adjudication. That's where the Navajo adjudication is underway right now. We're going to look to continue in the La Salle area and then the Monticello and Blanding areas. And then the Bear River adjudication is extremely close. A few objections and some addenda that need to be completed. And so I think that's an area that you'll see us focus on in the near future. And so I think we'll let Rick close here with a fantastic quote, and then we'll take some questions.
All right, thank you, Mike. I like this quote because it really drives home the complexity and the longevity of general adjudication processes This was by a lawyer in the Gila River federal general adjudication down in Arizona. One does not get out of the Gila adjudication. It is a sort of judicial black hole into which light, sound, lawyers, water, even Judge Goldfarb, indeed whole forests of paper will disappear. The only way out is out the other end. I don't expect to be special master for too many more years, but I do hope to be alive when this case finally goes to final decree. But bets are on. Thank you, everyone.
So we do have one last couple of questions. One is pending. I know some states such as Idaho have exemptions. For water rights pertaining to private residences. But is it correct that there is no such exemption in Utah and that every well owner must have their water right adjudicated?
That is correct. There is no exemption in the state of Utah for what we might call small domestic water rights. And so so there's a couple layers to this. The basic answer is yes, you will need to participate in the adjudication. However, there are sometimes shares in irrigation companies are used to evidence a well that is constructed on someone's property. In this case, you may not need to file a water user claim. And I know we all hate the word may. It's complicated. But generally the claim filed by the base irrigation company, the company that issues the shares, will suffice for that share evidenced water right. And we do have many of those in the state of Utah, that many individual single family wells that are evidenced by shares in irrigation companies. So that's the one exception, but I hope you see that still a water user claim is required. It's just a matter of who needs to file it. And in the case of an irrigation company, the company is the one that is intended or has the responsibility to respond on behalf of its shareholders.
So could the two of you briefly touch on the new water courts? Because these are heard at the state level, and now we have judges getting extra or in more intensive education on water rights, if I understand it correctly. So how is that working? How does that work?
Well, unlike Colorado has an actual separate system of water courts. Utah does not. And even under this new arrangement, it's a group of district court judges who have expressed a special expertise or interest in doing water cases. And this is a way that the parties can direct water cases towards a part of the bench that is perhaps better equipped to deal with the issues. If you've never sat in a water case before, represented someone in a water case, the learning curve can be quite steep. So this has been conceived as a way to direct those cases to where they can be best heard. And those judges get special training. In fact, Mike and I have been involved in that process in the recent past. So it's not an actual different court, but hopefully it will bring to bear some talents and skills that will be useful to people litigating water right cases.
So is it incumbent on the lawyers to ask for that a judge to be assigned, or does the court handle it on the back?
The parties ask.
Okay. And there's the list of the judges that do this, it's published somewhere so people can find it?
Correct. And I think the presiding judge decides where they go.
Okay.
That's about as much information as I have.
And so, Rick, as a special master, do you work with Mike on handling these cases, sort of as he acts as your expert, or do you guys ever conflict with one another? How does it work with the engineer's office and a special master?
No, the only thing I have worked with Mike on is these kind of presentations for general information. I'm a neutral. I don't work for the Division of Water Rights. I work for the court, and the state engineer is a party to each and every objection because it is her proposed determination that is being objected to. So we are not adverse, but we're certainly not aligned.
And maybe adding to that, I work through the Attorney General's office. And so most of my interface with either the special master or the district court is through those attorneys, and they report to me what's happening.
Okay. Well, I want to thank you both and thank everyone that was able to listen to this. If any of you have any ideas for future CLE, please let me know. I would love to hear your ideas. And before we end, I would like to just mention that the land on which the University of Utah sits and the University of Utah is named for the Ute tribe, is the traditional and ancestral homeland of the Shoshone, Paiute, Goshute, and Ute tribes. The University of Utah recognizes and respects the enduring relationship that exists between many Indigenous peoples and their traditional homelands. We respect the sovereign relationship between tribes, states, and the federal government, and we affirm the University of Utah's commitment to a partnership with Native nations and urban Indian communities through research, education, and community outreach. Thanks again, Rick and Mike, and thanks to all of you. Hope to see you soon.